and why it matters in the world, particularly those that are related to the faith, family, and values-oriented movement. Kevin McCullough, glad to be back with you on AFA today. I told you yesterday there's an increasing strain of activity that is happening in government that has concerned me greatly. We've seen traces of it through several different scandals that have come down in recent months. But, you know, when George Zimmerman's trial sucks all the oxygen out of the room, it's hard to get the government, much less the American people, to pay attention to some of the truly important stuff. And that's why I'm glad to have Brooke Goldstein back with us on AFA today, Kevin McCullough, and you being able to have this conversation. And we go live to her offices in Midtown Manhattan from the Lawfare Project. Brooke, welcome back to AFA today. Thanks for being here.
Me.
Let me ask you, you guys put out a white paper, the Lawfare Project, that is, just a couple of days ago. And before I get into the specifics of what that paper was about, why don't you give us just a thumbnail of what Lawfare Project attempts to accomplish?
Absolutely. So the Lawfare Project is a not-for-profit legal think tank. We're based here in New York, and we focus on a phenomenon called lawfare, the abuse of the law as a weapon of war. And we have a particular focus on the chilling of free speech as it involves public discussion about issues of national security and public concern, such as militant Islam, Islamist terrorism, and its sources of financing. But we've also been following the issues surrounding the NSA leaks with Snowden. And in particular, we felt it was incumbent upon us to put out an analysis of the Fourth Amendment and what exactly the Fourth Amendment protects vis-a-vis the privacy rights of American citizens, because there's been a lot of confusion focusing basically on Snowden's whereabouts, but not a lot of Americans really know what their privacy rights are under the Fourth Amendment.
Well, let's talk about that because as Mr. Snowden has captivated the media attention once again, it's been, you know, a lot of discussion about him, but not a lot of discussion about the essence of what he was telling people of what he knew. First of all, from the Lawfare Project's perspective, what was it about what Snowden was revealing should we be most worried about?
So the article that we're referring to is called Privacy in the Digital Age, and it was published originally in the American Thinker. It's also available on our website, thelawfareproject.org, and it was co-authored by myself and by Kara Goldman, as well as Benjamin Ryberg. And what we particularly focused on was the revelation that the NSA is collecting, doing what we would call dragnetting of the telephony metadata of millions and millions of American citizens. So basically what telephony metadata means is it's any type of transactional data that the telephone company has, except for the actual content of your telephone call. And this was authorized via court order that the NSA could collect the telephony metadata of Verizon customers. And what we are exploring is the doctrine of the third-party doctrine, which was articulated first in the late 70s by the Supreme Court, and which is the doctrine that has allowed the government to seize these types of records without a warrant. And if you want, we can go in and explain what that party doctrine is.
Well, and let me just say real quickly what the government told us when the metadata information, when it got out that Verizon they'd had this data collected, et cetera. What the president told us was, look, you can't really figure out any type of important information from the collection of this. This is just numbers called and times of days that it was dialed and so forth and so on. We were told that it was very important for us to be very concerned about this. You guys have described the process, but is there, before we get to the process of the third party issue, was that honest by the administration? Or were they playing a little coy with us?
Well, without going into the intent of the administration, I think that Americans should absolutely be very concerned, and they should take a good read at the ACLU's complaint, because in light of the digital age, it's not so easy to make the distinction between metadata records and what is personal information. And basically what the ACLU complaint says is, by virtue of collecting the data of millions of Americans over time, and by virtue of the fact that we use a lot of modern technology to make our telephone calls, that in aggregate, the government can learn what should be otherwise considered to be private information, where under the Fourth Amendment they would require a warrant. So basically what the ACLU is saying in sum is the collection over time of all of the metadata in light of the digital age will create a picture, as they put it, of our associations, of our public movements, revealing a wealth of detail about our familial, political, professional, religious, and intimate associations that should otherwise be afforded Fourth Amendment protections, and the government should be required to have a warrant to seize.
Sure. That's the voice of Brooke Goldstein. She's the CEO and director of the Lawfare Project here in Manhattan, and as she described it, a very important work that they are doing in tracking the idea of how law can be used against the citizens, and whether it's terrorists using our laws to try to advance radical Islamic belief in America, or whether it's our own government using escape clauses and hatches in the law to basically leverage our own rights and privileges. It is something that is a vital, vital work, and I would encourage you to find out more about it at thelawfareproject.org. That's thelawfareproject.org. Brooke, let's get into some of what, and this white paper that the three of you authored, and it was turned into an op-ed and has appeared, like you said, at the American Thinker, but is also available at thelawfareproject.org. I've got it linked to my Facebook page for people to go to today. You delve into the precedent of how the government is currently justifying this gathering of vast amounts of information and then basically conducting warrantless searches and seizures against us without our real knowledge of it. But there is a legal trick that they're playing. What is that?
Well, it's a very well-established doctrine by the Supreme Court. It's called the third-party doctrine. And what we argue is that in light of the digital age, if we continue to use this third-party doctrine as it was originally articulated by the Supreme Court in 1979, then we risk sliding down a very, very slippery slope where we will eventually have absolutely no privacy rights. So I think it's really incumbent upon us now, especially for your audience, to go through this step by step. So what does the Fourth Amendment protect? It protects, quote, the right of the people to be secure in their persons, houses, and papers and effects against unreasonable searches and seizures. And it also says that the government shall not be issue a warrant unless they can show probable cause. So obviously when the Constitution was written, the internet wasn't invented yet, and nor were we using the types of means of modern communications technology that we're using today. So what has happened is that, oh, and I forgot to mention also, in order to have, and this is absolutely essential, in order to have a reasonable expectation of privacy to something that requires a warrant to be searched and seized, that private property, you have to not only have a personal reasonable expectation of privacy, but it has to be one that society at large also agrees with, that there's a general consensus in the American population that this is something that is private. And I think also in light of the public outcry that emanated from members of the media and the general public and also the legal community in terms of what the NSA is searching and seizing, we can see that there is this public expectation of privacy to what is now called metadata, which we explained before.
Right.
There's one catch, and that is that the Supreme Court has said that you lose your reasonable expectation of privacy to something if you have voluntarily shown that to a third party. That is called the third party doctrine. If you have knowingly given someone content of an email, for example, that you would otherwise have a reasonable expectation of privacy to, you lose that Fourth Amendment protection. The government can seize that without a warrant by virtue of the fact that it has been knowingly shown to a third party. That's a third party doctrine. And traditionally, this was used, for example, with telephone records and with bank records. And so there was a monumental case in 1979. It was Smith v. Maryland, where the Supreme Court held that a pen register, which was something that was installed by the government at the offices of the phone company to record the telephone number somebody dialed from their home, the telephone numbers were knowingly revealed to a third party. Therefore, the government did not need to have a warrant to install that pen register. That was perfectly legal. And the reason that the Supreme Court used, and I'll quote here, was that all telephone users realize they must convey phone numbers to the telephone company. Since the telephone company's switching equipment that their calls are completed through, and all subscribers realize that the phone company has facilities for making records of numbers. We see this, for example, when we get the long distance. We get a telephone bill at the end of the month, which records the telephone numbers. So using this reasoning, because the caller has voluntarily given the telephone company the numbers they dial, they no longer have a reasonable expectation to privacy. The government does not need a warrant to search and seize that because of the third-party doctrine. Now, fast forward to 2013 and think about the future when everything we do in the digital age is arguably provided to a third-party provider. Everything you upload, for example, on iCloud, all of the documents you upload, even, for example, the content, even though it may be encrypted in certain programs, but even the content of your emails, for example, are email provider. Even Justice Sotomayor recently acknowledged in a case, Jones v. United States, that the third-party doctrine is ill-suited for the digital age. So what we're saying in this article is that if we continue to use this third-party doctrine, if the court continues to justify warrantless searches and seizures of metadata, for example, even the content of your telephone calls or your text messages, merely because you know and everybody knows that a third-party provider has access to it, then our Fourth Amendment right to privacy is going to be absolutely meaningless.
Well, this is something that you're not hearing discussed on even the major news channels, and you should be, because, friends, just this last weekend, another piece of very bad information came out regarding the harnessing of the average American's information and what they're going to do with it, and we're going to get into this in the next segment. But, Brooke, what you're really telling us here is that just with the Verizon case, for example, you have the opportunity to have your phone number, the time of day, all of the rest of that, that's already been confiscated, and we've been told that that's all that they have access to. But if they're using this third-party doctrine, and if the phone company actually keeps some sort of archived backup of the audio of every call that is made, and many of those phone companies are now doing that, though it may be of poorer quality than actual first time it's placed, et cetera, that ultimately it's the content of those calls that could be tapped into by the feds as well. And so really what you're establishing is nothing is safe if the third-party doctrine remains in place kind of untouched moving forward. Is that correct?
Correct. If the Supreme Court continues to use the third-party doctrine, it is foreseeable for them to reason that absolutely any type of digital communication that is knowingly revealed to a third party can be searched and seized by the government without a warrant. And I think that that's a very scary prospect. But I think it's also important to note that the director of the NSA has also come out and publicly said that all of the collected metadata in this NSA hub, so to speak, is going to be purged every 5 years. But, you know, knowing how technology works, and of course, in light of the NSA security leaks with Snowden, and the fact that, you know, many Americans don't really have any faith in how securely our information is being stored, despite the fact that the government is going to purge this from their own computers, that's not to say that this information can't be hacked. And
Right,
can't be
right. All right. So that's Brooke Goldstein, lawfareproject.org, the lawfareproject.org. We've got to take a break, and coming back, we're going to delve into a brand new way in which it appears that some of this may be applied by the administration, because it looks like Obamacare is going to make the NSA snooping that was done on phone lines pale by comparison. We'll get to the opinion of Brooke Goldstein and the Lawfare Project as we continue. I'm Kevin McCullough, live in New York. It's AFA Today. Don't go away.